Hello everyone. It is Saturday, October the 24th, 2015. I came across something I wanted to share with you at Bloomberg.com, and it's about a lawsuit that was done by a number of people in California. It seems that this was shared 4 hours ago, that Facebook wins dismissal of $15 billion users' privacy suit. Well, it looks like the corporate elites have won against us little guys again. And what caught my attention, which that didn't surprise me a great deal, they win all the time. They have a lot of money, and they can pay for an army of lawyers that have the highest degrees. But what caught my attention here mostly was why the people lost. It just took me by surprise on how come this happened. So let's just start going into the story. It is written by Joel Rosenblatt and Robert Burnson, who submitted this story. Facebook Incorporated won dismissal of a $15 billion lawsuit accusing the company of secretly tracking the internet activity of its users after they log off. After they have logged off of Facebook, Facebook is tracking every move they made, all of their internet activity. So these people decided, no, that's not cool. I'm not gonna allow them to do this to me. We're gonna sue these guys. You know, I have a right to my privacy. Well, the U.S. District Judge Edward J. Davila in San Jose, California, on Friday agreed with Facebook's argument that case should be dismissed because subscribers didn't specify how they were harmed. Are they kidding me? Because the subscribers did not specify how they were harmed? The judge, who took more than 3 years to issue his ruling after hearing arguments in the case, said the users could refile most of their claims in revised lawsuits. Facebook users alleged in a 2012 complaint that while they may have agreed to the company's installation of cookie files on their computers to track and transmit their web browsing, they didn't or did not consent to such monitoring after logging out of the social network. We all understand that when we sign up for a social media, we start posting our photos, personal information, etc. You know, we're agreeing that, hey, we've put it up there for the public and we've submitted it ourselves. But it isn't cool that after we've logged out of their networks for them to keep up with us on every move we make. We didn't agree to that. And these people had every right to complain. And I disagree with this reason for dismissing this case, as the subscribers didn't specify how they were harmed. Of course they were. Of course they were. And I'll show you that in a minute on how. In the San Jose case, the plaintiffs accused Facebook of violating the U.S. Wiretap Act by monitoring their online activity while they weren't logged on, were not logged on. They also accused Facebook of improperly profiting from their information. Facebook sells everyone's information to a third party. Then that third party sells it to a fourth party, and then to a fifth party. Everyone makes money off of you and me. They do it all the time, and they have for a long, long time. But now they're up to even more dastardly things. And that's keeping up with us when we even sign out of their websites, so that their advertising and their third-party affiliate advertisers can target us in a private way. If you go to eBay, they know it. And the next thing you know, you're on another page, and the very things you were looking at on eBay are popping up for other affiliate sites, you know, for Facebook or somebody like that. And you're going, how did they know? Where did that advertisement come from? I've said that before. I was just over at eBay, and now I've got an eBay advertisement on another page somewhere else that had nothing to do with them. Has nothing to do with Facebook or anything. But yet, someone made a cookie of where I was going and everything I was doing, and selling that information to someone else. The judge said the users failed to adequately connect the value? The value? Are you kidding me? Of the data collected by Facebook to a realistic economic harm or loss? So when is it that we must prove we have a loss or have to put a value on our own privacy? When did this start? It makes no sense. Specifically, the plaintiffs failed to show they personally lost the opportunity to sell their own information, or that the value of their information was somehow diminished after it was collected by Facebook, Judge Davila said. Okay, so they're not denying that Facebook collected the information on the people while they were offline and not connected to their site. That's not disputed here. Notice that? What their dispute is, it's the, you know, how did Facebook did they use the information to diminish it in any way? That was what was the important matter here to the judge. That makes no sense. They personally lost the opportunity to sell their own information. What? That's kind of out of left field. What are they talking about? Why would I want to sell my own information? Because the other guy got a heads up over me, so therefore I didn't take the opportunity first to sell my own information. Therefore he's okay? He can go ahead and do that? I mean, that's what it's saying here to me. I don't agree at all with any of this. Matthew Brown, a lawyer who represented Facebook at a 2012 hearing before Judge Davila, told the judge that the user's complaint suffers from an utter lack of allegations of any injury to these particular named plaintiffs. So, you have to have physical injury or your data injured or your information injured for there to be any action taken. That your civil rights, your constitutional rights were violated is not enough according to this judge. A judge of the land, of the courts, that is supposed to institute judgment of law with justice. But where is the justice for the plaintiffs in this case? As a matter of fact, what the judge had set up here in this other area, that the plaintiffs, they personally lost, okay, that it was collected by Facebook, whatever. I'm talking about, he set it up here because subscribers didn't specify how they were harmed. The judge says that. Then when you go down here and look at Brown, you know what Brown said right there, He says the judge was just repeating the very same thing that the Facebook lawyer had said right there. I see no injury here. Case dismissed. In favor of Facebook. Facebook, evidently it was found they did collect the data when these people were offline, not connected to Facebook. But that didn't seem to be breaking any law. Brown argued that the plaintiffs failed to identify what websites they visited, what kind of data or information was collected, or whether Facebook used it or disclosed it to anyone else. Excuse me. This is just ridiculous. They are coming here saying that the plaintiffs must identify whatever websites they visited, every one of them. I mean, I don't know about you, but I don't remember every website I visit. I shouldn't have to keep up with that. Why is that my responsibility? Why do I have to answer to Mr. Brown on what websites I visit? And why do I have to disclose that to anyone? Isn't that part of my privacy? Should be. What kind of data or, what kind of data or information was collected? How are we going to know that? How could the plaintiffs know what data or information was collected since it went into Facebook's computers? They have the evidence. They hold that evidence. So of course, he's going to make this argument to someone who does not have that data. And he says further, or whether Facebook used it or disclosed it to anyone else. Now, there again, how are the plaintiffs going to know whether Facebook used it or disclosed it to anyone else? Because it's on their computers at Facebook. How can they know? Could the plaintiffs go and subpoena Facebook and say, we want the databases of all your computers that we can get our guys to peruse through to find out what data you did collect on us and who you did sell it to? Right. That would go over real well. And it would be a mountain of information to go through that would probably take years. So he had a double-barrel shotgun right there when he said that. I'm incensed by it. I don't know about you, but I am incensed by this. So let's find out what rights were violated. The Fourth Amendment to the Bill of Rights says the right of the people to be secure in their persons, their houses, their papers, and their effects. The effects could be your computer, the data on your computer, where you surf, where you go, what data that you have, even in your temporary internet files. They should not be anyone else's business. That's part of your effects. And you should be secure in all of these things against unreasonable searches. Not only did they search, but they seized. They seized that information while those people were offline. That's illegal, according to, the Bill of Rights of the United States. But the judge didn't see it that way. Never was that mentioned as far as the report went that I read. That it shall not be violated. Did it say government here? Did it say personal persons, hackers? Did it say any particular entity's name in this amendment? Nope. I only see the right of the people to be secure against unreasonable searches, seizures. I mean, that should be from anyone. And that's how I'm reading that here, because no one has been specified in particular. It shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. That part is probably government. But the first part of this, there is no name attached to who they're protected against in particular. It means everybody. Anyone who comes to try to take your privacy without your consent is unreasonable searches and seizures of your private property, of your private surfing and your privacy. Let's go to 9, Amendment 9 of the Bill of Rights. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Want to know what that means? Okay, let's go over it. Here it is. Here's the United States Constitution. Enumerated rights and reserved powers, Amendments 9 and 10. I'm just going to read 9. The 9th Amendment came out in 1791. That's how long we've had that amendment. It declares that individuals have other fundamental rights in addition to those stated in the Constitution. Because the rights protected by the 9th Amendment are not specified, they are referred to as enumerated. And the Supreme Court has found that enumerated rights include such important rights as the right to travel, the right to vote, the right to keep personal matters private, and to make important decisions about one's health care or body. No one has a right to stick their nose into your health care information. They do not have a right to put their nose into your business about your travel without probable cause by law enforcement or whatever. I'm talking about innocent people. People who are law-abiding citizens of the United States, not up to any kind of shenanigans. You have a right to keep personal matters private under your 9th Amendment right that came out in 1791. But did the judge ever mention this 9th Amendment? Nope. Sure didn't. So we not only have the 4th as well as the 9th constitutional right. And probably the wiretapping law has been broken as well. So, you know, I just had to bring that out to your attention. It bothered me a great deal. I thought it might interest someone else who these things matter to. And thanks for listening. Hope you have a good one.